can a trial judge, acting alone, dismiss the strong objections of state prosecutors and permit an accused in a drug trafficking case to plead guilty to a mere possession charge? What happens when the very institutions entrusted with our justice system, the Supreme Court, and the Department of Justice find themselves in disagreement over the rules of plea bargaining? And ultimately, for you watching or listening, what does this legal tug-of-war signify for the pursuit of justice in our nation, particularly in those highly publicized drug cases that capture our collective attention?
Welcome to the Deep Dive. We're here to unpack the crucial legal developments shaping our country, and today we're tackling exactly those questions.
That's right. We're diving deep into a really significant Supreme Court case. It gets right into the heart of plea bargaining and drug offenses and, that delicate power balance between the courts and the prosecution.
Exactly. We're looking at People of the Philippines versus Edgar Majingcar and Yabut and Christopher Ryan Llaguno y Matos. That's GR number 249629, dated March 15th, 2021.
And our mission today is pretty clear. Break down this important ruling, understand how we got here, look at the arguments, and really explore what it means for the justice system in the Philippines. We want you to walk away with a solid grasp of this. So let's jump in.
Okay. So it all starts back on October 5th, 2016, down in Naga City. We have two individuals, Edgar Majingcar and Christopher Ryan Llaguno. They're facing some serious drug charges under Republic Act 9165.
The Dangerous Drugs Act, right?
Correct. The first case, criminal case number 2016-0774, was for Section 5. That's the sale, dispensing, delivery of shabu. We're talking a pretty small amount, 0.056 grams, but still, it's the sale charge.
And there was another charge, too.
Yes, a related one. Criminal case number 2016-0775. This was for Section 11, simple possession, allegedly 0.309 grams of shabu.
Okay, so two separate cases, sale and possession.
Yeah.
How did they initially plead?
Standard procedure, really. They pleaded not guilty at their arraignment, and the trial started to move forward.
But then things took a turn towards plea bargaining.
Both respondents, Majingcar and Llaguno, proposed pleading guilty, but not to the original charges. They wanted to plead to a lesser offense under Section 12 of the same law.
Section 12, what does that cover again?
That's possession of drug paraphernalia. So definitely a less serious charge than selling drugs or even possessing the drugs themselves. They pointed to AM number 180316SC as their basis.
Ah, the Supreme Court's own framework for plea bargaining in drug cases.
Exactly. They were using the court's guidelines to argue for the lesser plea.
Now, the prosecution has to agree to this sort of deal, don't they? It's not automatic.
That's the crucial point and where things get complicated. For the sale case, the more serious one, 0774, the prosecution said no. Well, actually, they made a counteroffer.
Oof.
They suggested the accused plead guilty to Section 5, the original sale charge, but maybe get the penalty that corresponds to possessing a smaller amount under Section 11, paragraph 3. So still guilty of sale, but maybe a lighter sentence.
I see. But what about the possession cases, 0775?
There, the prosecution actually didn't object to them pleading guilty to the lesser offense, Section 12.
So agreement on one, disagreement on the other. How did the trial court handle this split?
This is where it gets really interesting. The trial court, in a resolution dated August 6, 2018, decided to allow the plea to the lesser offense, Section 12, for both cases.
Both. Even the sale case where the prosecutor objected?
Yes. They overruled the prosecution's objection in the sale case, and they didn't stop there.
Oh, what else?
The trial court went ahead and declared several Department of Justice issuances, specifically DOJ circulars 061 and 027, plus a regional prosecution office order, unconstitutional.
Whoa, hold on. Unconstitutional. Why would the trial court do that?
Their reasoning was that these DOJ circulars, which likely guided the prosecutor's objection, were infringing on the Supreme Court's exclusive power to make rules about court procedure. They cited that Estepona versus Labrigo case and the SC's own plea bargaining framework, basically saying the DOJ was telling courts how to apply procedural rules.
So the trial court was really pushing back against the DOJ guidelines.
You could say that. Asserting judicial independence, perhaps. The prosecution, of course, asked for reconsideration.
Makes sense.
But the trial court denied it. So things moved forward based on the court's decision. On September 5th, 2018, Majingcar and Llaguno were rearraigned.
And they pleaded guilty to Section 12 for both charges.
Correct, following the court's resolution. And just a couple of weeks later, September 18th, the trial court issued its judgment, finding them guilty of violating Section 12 in both cases, and gave them the sentences imprisonment and fines.
Seems like a done deal at the trial level then. But I guess the prosecution wasn't finished.
Not at all. The people, through the prosecution, elevated the matter. They filed a petition for certiorari with the Court of Appeals.
Right, arguing the trial court messed up, basically.
Right.
Grave abuse of discretion.
Precisely. But the Court of Appeals, in a decision on April 5, 2019, dismissed the petition.
Dismissed it. Why?
Two main reasons given by the CA. First, they said the petition was filed late beyond the 60-day window.
Ah, a procedural issue.
Yes, but they also addressed the substance. They said even if it was timely, it lacked merit. The CA found no grave abuse of discretion by the trial court. They agreed with the trial judge's reasoning, citing Estepona again, and importantly, they upheld the trial court's declaration that the DOJ circulars were unconstitutional.
So the Court of Appeals backed the trial court completely. Late filing and no error found.
Pretty much. The prosecution tried again with a motion for reconsideration, but the CA denied that too in September 2019.
Okay, so trial court and CA aligned. This inevitably leads us to the Supreme Court. What were the core issues they had to resolve?
There were several big ones. First, was the CA right about the petition being filed late, that timeliness issue?
Okay.
Second, and this is the heart of it, did the CA err in upholding the trial court's decision to allow the plea bargain, especially in the Sale case where the prosecutor had objected?
The consent issue.
Exactly. Third, was the CA correct in affirming the declaration that those DOJ circulars were unconstitutional? And finally, a fundamental question. Did this whole challenge by the prosecution violate the accused's right against double jeopardy? You know, being tried twice for the same thing.
Right, because they had already pleaded guilty and been sentenced by the trial court. Lots to unpack there. How did the Supreme Court rule?
Okay, let's go through it. On the timeliness point, the Supreme Court actually disagreed with the Court of Appeals.
Oh.
Yes, they recalculated the 60-day period. They said it should run from when the prosecution received the judgment, not just the earlier resolution. Based on that, the filing date of November 16th, 2018 was within the 60 days. So the petition was timely filed.
Interesting. So the CA got the dates wrong. What about the plea bargaining itself?
Here's where the SC differentiated between the two cases. For the possession case, criminal case 0775.
The one where the prosecutor didn't object.
Right. In that case, the Supreme Court affirmed the CA. They said since the prosecution consented, or at least didn't object, the trial court acted within its discretion to approve the plea to Section 12. So the conviction for the lesser offense in that case stands.
Okay, that seems logical. But the Sale case, 0774, that's the controversial one.
And that's where the Supreme Court reversed the lower courts. They ruled that the trial court committed grave abuse of discretion by approving the plea to Section 12 over the prosecution's objection.
So they sided with the prosecution on that.
Unequivocally. They pointed directly to Section 2, Rule 116 of the Rules of Court. It requires the consent of the prosecutor and the offended party, if any, for a valid plea bargain to a lesser offense. Without that consent, the court simply can't approve it, especially when the objection is, as they said, vehement.
That's a very strong clarification on the need for prosecutorial consent. What about the constitutionality of the DOJ circulars? The lower courts struck those down.
The Supreme Court reversed on that point, too. They were quite critical of the trial court, saying it acted with gross ignorance of the law by declaring DOJ Circular Number 27 unconstitutional motu proprio meaning on its own initiative without the proper legal challenge being raised.
So the trial court shouldn't have even ruled on that?
Not in the way it did. The SC reiterated its stance from another case, Serre versus Zenos. They clarified that DOJ Circular 27 doesn't clash with the Supreme Court's rulemaking power. It's viewed as an internal guideline for prosecutors, part of the executive branch's function, not a rule of court procedure that the judiciary controls.
Got it. So the DOJ guidelines are valid internal rules for prosecutors. Now, what about double jeopardy? Did that argument hold water?
The respondents argued they couldn't be tried again for the Sale charge since they'd already pleaded guilty to the lesser offense.
A classic double jeopardy claim.
It is. But the Supreme Court said, no, double jeopardy doesn't apply here, specifically for the Sale case, 0774. They cited an exception under Section 7, Rule 117 of the Rules of Court.
An exception?
Yes. The rule basically says that if a plea to a lesser offense is made without the required consent of the prosecutor, it doesn't validly terminate the original case. Therefore, it doesn't bar further prosecution for the original, more serious offense.
Ah, because the plea itself was flawed due to the lack of consent.
Exactly. The foundation of that plea was defective in the eyes of the law.
So, summing it all up, what was the final outcome, the disposition from the Supreme Court?
The Supreme Court granted the people's petition, but only in part. For criminal case 0774, the sale of drugs charge, the decisions of the Court of Appeals and the trial court were reversed and set aside. That case was sent back, remanded to the trial court in Naga City for further proceedings on the original Section 5 charge.
Meaning they could still face trial for selling drugs.
Correct. But for criminal case 0775, the possession charge, where the prosecution didn't object, the Supreme Court affirmed the Court of Appeals. So the conviction for the lesser offense, Section 12, in that specific case, remains valid.
Okay, that's a really important distinction. So what does this all mean for you, our listener?
Well, this case really hammers home that the prosecutor's consent is absolutely vital in plea bargaining, particularly in drug cases under RA 9165.
It really does. A trial court can't just ignore a prosecutor's strong objection and allow a plea to a lesser charge. It reinforces the specific roles within the system.
And it also, reaffirms the Supreme Court's power over court rules, but clarifies that DOJ guidelines for their own prosecutors are perfectly constitutional internal directives. It's about boundaries, isn't it?
It is. It shows those checks and balances.
Yeah.
Plea bargaining is useful, yes, for efficiency, but it can't undermine the prosecution's role or the state's interest, particularly in serious crimes like drug trafficking.
So thinking about all this, what aspect of this decision really stands out to you? What do you think is the most significant takeaway about how our legal system works?
We'd love to hear your thoughts on that. Drop your comments below. And hey, if you found this deep dive helpful, please hit that favorite button. Absolutely. Let's just quickly recap the key legal ideas, the doctrines reinforced by this case.
Sure. First, plea bargaining in drug cases. The big one requires the prosecutor's consent. No consent, generally no valid plea to a lesser offense, especially if objected to.
Right.
Second, rulemaking power of the Supreme Court. The SC has the sole authority over court rules and procedures. That's reaffirmed.
Okay.
Third, judicial review. Courts can declare laws or issuances unconstitutional, but only if very specific conditions are met: actual case, proper party, raised at the right time, and it being the core issue. You can't just do it proactively.
Got it.
And lastly, double jeopardy. A fundamental right, but it has exceptions. Pleading guilty to a lesser offense without the prosecutor's consent is one such exception. It doesn't prevent prosecution for the original charge.
Excellent summary.
Yeah.
If you want to keep getting these kinds of insights, these deep dives into important legal rulings and what they mean for all of us, make sure you subscribe to The Deep Dive.
We'll keep breaking down the complex cases and giving you the knowledge you need. Thanks for joining us.